Welcome to the latest Eversheds Sutherland Legal Insights podcast.
My name is Angharad Hurle and I'm a legal director specialising in inquiries, inquests and confidential investigations. Today's episode of Through the Inquisitor's Lens is titled, What Might the Public Office Accountability Bill Mean for Organisations? And I am joined by Emma Gargitter, barrister at Red Lion Chambers. Emma practices in criminal, regulatory and professional disciplinary and public and administrative law. Her practice has a particular focus on terrorism and other cases with a national security element and public inquiry work. She has a particular interest in cases which straddle the criminal and public and administrative law spheres. We will discuss who the Public Office Accountability Bill will really impact and consider how organisations should prepare for its implementation. We hope you enjoy.
Thank you for joining me today, Emma, to discuss the Public Office Accountability Bill and who it will really impact. And shall we start with a little history lesson, maybe?
Yes.
The bill's origins can be found following the Hillsborough disaster in April 1989. And the investigation was conducted by Bishop James Jones after that, who reported to government in 2017. And as you know, he called for a statutory duty of candour. And that's been repeated many times, really, since then by various public inquiries. And I think the most recent example of that was by Sir Brian Langstaff in the infected blood inquiry. Yeah. And I think we're all anticipating something similar from Sir Wyn Williams when he makes his anticipated report for the Post Office Horizon IT scandal. So there has been significant political and public support for this for many years, well, decades. And this is often referred to as the Hillsborough Law as a result of its origins. And whilst the original calls were for a public bodies to have this duty of candour, it isn't really all about public sector now that the bill, we've actually seen it on paper. And also we can come on to discuss who that's likely to impact. Based on its current drafting, the long title for the bill describes its purpose as to impose a duty on public authorities and public officials to act with candour, transparency and frankness, to make provisions for the enforcement of that duty in their dealings with inquiries and investigations, to require public authorities to promote and take steps to maintain ethical conduct within all parts of the authority, to create an offence in relation to public authorities and public officials who mislead the public, to create further offences in relation to the misconduct of persons who hold public office, and to abolish the common law offence of misconduct in public office. It also makes provisions to enable persons to participate at inquiries and investigations where the conduct of public authorities may be an issue and for various connected purposes. So bearing all of that in mind, Emma, who do you think the bill is likely to predominantly impact?
Well, as you say, I think its genesis is obviously the concern that came about as a result of the involvement of certain public bodies in those quite prominent public inquiries. So Hillsborough, Grenfell's another one that's mentioned, infected blood. And as you say, Horizon Post Office is likely to have also quite a big impact, even though it hasn't yet reported. So really, although that's the genesis of it, I think the bill goes even wider. As you say, it's not confined itself to inquiries. It's actually seeking to really cement what are often referred to as the Nolan principles in public standards of public life much more widely. And in all public authorities, it targets not just the authority as a body, but there are specific provisions in this bill for those who are effectively in charge of the body. So it's seeking to fix individuals who are in charge of them with responsibility. And there's also provision, so whilst there is a schedule listing the public bodies that are affected by the various provisions, there's also a sort of catch-all provision for bodies that are exercising public functions or public functions as part of what they're doing. So it's drawn quite widely. It's anybody really who's exercising a function in the public interest needs to get to grips with what this bill requires of them. And we'll come on, I think, in most detail, given our specialisms in sort of public inquiries and inquests. We'll come on to the specific provisions in relation to those, I'm sure. But the wider aim seems to be to impose obligations about ethical conduct whether or not there's an investigation or an inquiry underway. So I think public bodies need to really be aware of what's coming.
Yeah, and I think that's the really interesting. I think that's the area that's also been up for quite a bit of debate, hasn't it? Where it's the bill is really catching private sector organisations as well now in two main routes. So either those, as you say, who perform in public functions of a public nature, but also those who have a relevant public responsibility via health and safety obligations as well,
Yeah,
isn't it? So
yeah,
it is certainly far wider than I think a number of people anticipated it would just be for public sector, public authority entities.
yeah,
But with those kind of clauses within it, it really has the potential to go far, far wider. But
yeah.
how far, I think, is still yet to be determined, essentially, isn't it?
Yeah, agree, absolutely. And of course, those bodies are exactly the sorts of bodies that are likely to find themselves involved in a public inquiry or an inquest. So
Yes.
they need to be ready for that aspect generally, as well.
Yeah. And yeah, from our collective experience, obviously we've had a lot of involvement in both inquiries and inquests and the wider investigations of that. So what kind of impact do you also see this having on the inquiries and inquests as well? So sort of kind of the flip side, I suppose.
Yeah, so I think the bill's actually quite interesting for inquiries and inquests.
Mm.
There's clearly quite a strong desire to make some changes to certain aspects of the
Yes.
inquisitorial sort of process, and the sorts of bodies that run inquisitorial processes. So the provisions are new in the sense for a public inquiry, a statutory inquiry. This bill is proposing to make quite significant amendments to
Mm.
the 2005 Inquiries Act, which will be the first time that that has really happened in
Yes.
20 years.
Yep.
So the duty of candor, which is the sort of primary function, in a sense, the headline function, that the bill is imposing in relation to inquiries, inquests, and investigations, is going to be written into the Inquiries Act so as to make it enforceable,
Yes.
by an inquiry chair. And so I think it's interesting, firstly, that there's significant amendment proposed to the Inquiries
Mm.
Act for the first time to really
Yeah.
try to give a chair of an inquiry or an inquiry panel the teeth to enforce the duty of candor. We can
Yeah.
come on maybe to how effective that might be, but certainly the aim of the bill is clear that they want to make this enforceable. I think the second way in which it's interesting from an inquiry perspective is that the way that the bill is drafted in the schedules is to give non-statutory inquiries
Yes,
there's
I was going to
almost
ask
the
you.
same powers as a statutory inquiry. Now, we've seen with this government when it came in what appeared to be a strong desire to make non-statutory inquiries as important, as it were, in the public mind
Mm.
as a tool for investigating matters of public concern as
Yes.
statutory inquiries. And that seems to stem, I think, from mainly from the idea, backed up in part by the data, that non-statutory inquiries are often cheaper and
Yeah.
quicker than statutory inquiries. So there was obviously a big desire from this government to pursue the non-statutory inquiry route and put it on a similar footing. And this bill seeks to do that. So,
Yes.
for example, the power that is given to the chair of a statutory inquiry to issue a compliance notice, what's called a compliance notice. So saying to a public authority very close to the outset, I think you've got relevant information
Yes.
and you're subject to the duties in this act to give it to me, to tell me what's important in it.
Yes.
It's going quite far. That those powers are being given also to a non-statutory inquiry.
Yeah.
So again, I think that's a change which comes from this desire to make non-statutory inquiries equally effective, equally
Yes.
trusted as a statutory inquiry. So I think that's quite an interesting aspect and will affect inquiry practice to a certain extent. At least inquiry lawyers need to be aware that non-statutory inquiries will have those powers if this bill goes through as it
Yes.
currently stands.
And I think that's also quite important from a public perspective as well, isn't it? Because quite
Yeah.
often when the campaign groups are campaigning for a public inquiry, they feel that it has to be statutory, failing which it isn't going to really get
Yeah.
all of what it needs to really fulfill the terms of reference and to quell those concerns that they've had, I say, sometimes for decades. And now seeing this shift to provide more of those powers to the non-statutory inquiry as well, I think is really interesting, as we
Yeah.
have seen some non-statutory inquiries in recent years, for example, awarding or designating certain entities as interested parties, essentially,
Yeah.
which is their equivalent of a core participant, whereas technically there is no basis for that. But you can see these non-statutory inquiries starting to have a bit of a hybrid, really, isn't it?
Yeah.
But this, I think this bill and the additional teeth that it's going to give those non-statutory inquiries as well, I think is actually going to be really interesting from a campaigner's perspective over the next few
Yeah.
years as well, and see how that changes things.
Yeah, absolutely. And I think allied with that, what you see in the bill are provisions that are um, intended to improve the efficiency and effectiveness of inquiries, whether they be statutory or
Yes.
non-statutory, trying to save on the costs of legal representation as
Yeah.
well. So we've got a proactive duty on public authorities to bring relevant information to the attention of the inquiry, so they can't sit back and wait for a request. And
Yes.
allied to that, the duty on the public authority to make sure its legal representation is proportionate.
Yes.
Interestingly, the bill's also seeking to impose on the legal representatives who representing the public authorities or bodies that become involved in because they have a public function, to impose duties on their lawyers to act in accordance with this. Now, for lawyers, that may not come as a great surprise, but it's quite interesting, I think, to
Yeah.
see in a prospective statute an explicit duty being placed on the legal representatives who act in inquisitorial processes to act in line with these duties, to be
Yes.
proactive, to be transparent at all times, to ensure their clients acting with appropriate frankness. So I think that's also interesting that you can see the bill trying to improve efficiency and effectiveness by
Yeah.
putting the onus on the public authority participants to be active and upfront about all of this rather than drag their heels, which
Yeah.
sometimes I think we've all experienced sometimes that can lead to delay in public inquiries, which is obviously a
Yeah.
big problem for the effectiveness of inquiries and public trust in them to actually reach a result.
Yes. And I think it- following on from that as well, I suppose it is in inquest in particular and disparity of arms as well,
Yeah.
to ensure that those bereaved and the families actually have the ability to obtain that legal support for them throughout the proceedings as well, which again, it is this shift, isn't it, towards this
Yeah.
effectiveness, fairness,
Yeah.
and you can just see the themes of that repeating throughout the whole bill as it's currently drafted in any event.
Yeah,
Yeah.
absolutely agree. And I think for the inquests, the legal aid change, it's been a long time coming.
Yes.
A lot of campaigning has gone into it. A lot of examples where family members of the deceased have felt, that they're facing a barrage of lawyers.
Yes.
Yes, it's an inquisitorial process, but everybody else is lawyered up from their
Yeah.
perspective, and
It
they
can feel far
can't.
from inquisitorial at times, can't it? As you say, when you've
Absolutely.
got that wall of legal minds facing you. So yeah.
Absolutely. And that's another theme, I think. It is all part of the theme that there's the government wanting to ensure that these processes remain inquisitorial and don't become adversarial. Perhaps it
Yes.
comes from a cost-saving perspective because it's generally thought to be more efficient. But you see there's provision in the schedules for the Lord Chancellor to amend the rules, for example, the inquiry
Yes.
rules, and to put in an overriding objective that public authorities should bear in mind, which includes reference to keeping the processes inquisitorial. So I
Yes.
think, yeah, the parity that, impact on the inquisitorial nature of things, all part of a theme running
Yes.
through.
Yes, certainly. So, as things currently stand, obviously the bill is not yet law, and it has hit a slight stumbling block in its third reading.
Yeah,
But as we've discussed, really, the direction of travel is quite clear. And based on the first and second reading, there were minimal amendments to it. And, save for these, the potential changes in light of the concerns raised around the obligations for intelligence services, which is the stumbling block, as it were, in the third reading. With the political and public desire to implement this as soon as possible, and it has had a lot of momentum to date, it appears to me those entities that we discussed slightly earlier really need to start thinking about the impact this may have on them, and their functions in particular, and how they prepare for events they may not actually know or have not actually occurred yet. They may not even know that they're facing these down the line. So how do you think some of those entities should best start preparing for it? Because I think the message is quite loud and clear that as soon as this does become law, those public bodies are going to be bound by it immediately.
Absolutely. And just as a slight sort of side matter before I come on to your question,
Yeah.
the bill makes provision for these powers that are going to be given to inquiry chairs and coroners to come into effect for inquiries and inquests that are ongoing.
Yes, exactly.
When at the point of enactment. So it's going to hit some people very soon indeed.
Yep.
One of the things that, in my experience, often troubles an inquiry and its public authority, public body called participants, is disclosure of documents. And there have been a number of inquiries where government departments, for example, have struggled to identify relevant material, to marshal it and provide it to an inquiry in a timely manner. There are really two ends of the spectrum that a public body can adopt when historically faced with a request from an inquiry, either simply to hand over everything that might be relevant and leave it to the inquiry to sift, which means the inquiry takes longer to get to the end of that process, or for the public body, the government department itself, to spend the time trying to figure out what's relevant. But if you are for the government department or public body, that comes with the risk that you might miss something. And of course, the duties in this bill are enhanced. You've got to make sure you're not missing something. And often at the root of those difficulties, that is for the government department or public body trying to itself sift for relevant material, often at the root of that are its own document management difficulties. So I think what public bodies need to start thinking about now, if there's any chance that they might be involved in a public inquiry, is making sure that their record keeping is fit for purpose. And that's easier said than done, but it's going to be very difficult to comply with these duties to a public inquiry, statutory or non-statutory, or a major inquest, if you can't find or identify whether or not you've got relevant material in the first place. That the bill puts the onus on the public authority to say to the inquiry proactively, yes, we've got relevant material, here it is, here's what's important amongst that material. Public bodies need to be ready to be able to identify that material and do it early, because the bill envisages that this is going to happen at the very outset of an inquiry or an inquest, not some months or years in.
And I think that also leads to another interesting angle, I suppose, as well, Emma, doesn't it? Could this also have a detrimental effect on some of those inquiries, investigations, and inquests, in that, do you think people will be concerned around failing to comply with a duty, that they end out actually over disclosing documents or providing such a volume of documents to those investigations that it has a detrimental effect? So, it could end up drowning them with documents for fear of falling foul of the act.
Yeah, I do think that's a risk. I mean, what the bill builds in, assuming it passes as currently structured, it builds in a measure of control for an inquiry chair or a coroner. So it's for the chair or the coroner to issue a direction to a public body to comply, and within that direction it would be open to an inquiry to specify exactly what it's after. But it's a bit of a chicken and egg situation, because often
you don't know what you don't know when you start.
Exactly. So I do question how effective this will be. I think it's well intentioned, certainly. What's very welcome is a duty on the public body to act expeditiously when responding to
Yeah,
these things, which I think may help an inquiry or an inquest. It gives them
certainly.
a measure to fall back on if a public authority appears to be dragging its feet on these things. But I agree, there is a risk of these investigations being swamped with material because of a concern on the part of well-meaning government
Mm,
departments or public bodies, a concern that they'll be caught out not complying with these duties.
yes. Yeah.
Um, so yeah, I
Yeah.
think that's a risk to watch out for.
And I think in terms of other preparations as well, there's obviously reference to um, ensuring that all of your staff are aware of their duties and obligations. So, just from a practical perspective, there's obviously going to be a significant amount of training that's required and educating your workforce on
Absolutely.
the duties. And as you say, I think the disclosure element could be quite difficult. Um, but if they are prepared for that and to ensure that they have the right processes and procedures in place across the board, I think it comes back to a lot of the governance as well, doesn't it? And again, back to our collective experience, if we look at various recommendations from inquiries over the decades, they all come back to governance failings, really, don't they? So I
Yeah.
think this is kind of also an opportunity for a number of those authorities, establishments, so anybody that could be captured by this to hit the reset button on some of their internal governance, actually.
Yeah, I think that's a good point. And the other parts of the bill that we haven't really touched on, the requirement to have a sort of code of ethics in
Yes,
place
exactly. Yeah.
is, I think, designed to bolster that aspect of things. And there's going to be quite a lot of work, I agree, in training, ensuring policies are up to date and fit for purpose, appropriately notified to staff and staff trained to really understand what it's going to involve in their job,
Yeah.
so that the bodies can show compliance.
Yeah. And I said earlier on, I think that it's quite clear the direction of travel with this. And I from what I've read, at least in the press, it's unlikely that there are going to be significant changes between now and when the law becomes enacted, say for what they potentially do with this intelligence service as part of it. Um, do you agree with that? Do you think that really I think a number of clients or entities would potentially think, oh, well, it's not law yet, so I'll just hold off.
No,
But
I agree with you. I mean, this was first introduced, I think, by Andy Burnham back in
it was,
2017. So
it was,
it's been coming for a while. It clearly has the backing of this government.
yeah,
It's quite a strong piece of draft legislation, I think, in terms of the themes and the direction of travel that you can see quite obviously. And it's backed by, as you say, multiple terrible experiences of people affected by public tragedies. Hillsborough, Grenfell, Horizon Post Office is going to only add to it. Infected blood.
yes,
There's a lot of momentum. And also just generally, I think in the last 5 or 6 years, standards in public life have been a broader concern, and this feeds into that. So I think there's a lot of momentum to get something like this, or very like this bill passed.
yes,
And I don't think it's going to be long, as you say, subject to that one issue with the intelligence community. I don't think it's going to be very long before this is on the statute book. And I don't see it being significantly watered down.
no,
There doesn't seem to be an appetite for it. And
none
it's,
at all.
yeah, so I think
Yeah,
I agree. Clients need to anticipate this or something very like it on the statute books in the not too distant future. And as I said before, it will hit if you're involved in a public inquiry now, it will hit you very, very quickly.
yes,
And if not now, there are public inquiries will be set up involving public authorities, and that will continue to happen.
yes, yeah. Well, thank you very much for your time today, Emma. I think that's been a very helpful debate as to, the impact this is going to have on various entities, public and private, actually. And I think that's the bit that everybody needs to bear in mind, that this does go further than what it started off as, and I think is what is publicly being perceived as. It is for public authorities and officials only.
Yeah.
It certainly is going to go further than that. So I know I'm very interested to see how this is going to change things going forward, particularly obviously from an inquiry and inquest and general investigations perspective as well. But I can see it impacting in quite a large way going forward. So I think it's very interesting times ahead.
Absolutely. And thank you for having me.
Yeah, thank you, Emma.
Thank you for listening to the Eversheds Sutherland Through the Inquisitor's Lens podcast.